Good afternoon, everyone, and I want to thank everyone for coming out today. I'm glad to see that my last name wasn't a deterrent for too many people. My last name is Schietzelt. It's pronounced Schietzelt. I'm Mike Schietzelt. I am the Criminal Justice Fellow for the John Locke Foundation, and as Donna mentioned, I'm very new to the organization. Previously, I had worked for Chief Justice Martin on the North Carolina Supreme Court as a judicial law clerk. And during my time at the Supreme Court, I got to work on a number of very interesting issues, very complex issues. I got to work with one of my colleagues on shareholder litigation. I got to work on constitutional amendments, separation of powers, and more constitutional amendments. That seemed like it came up every other week. But one of the issues that was always most frustrating for me were the criminal issues. And not the intricate, detailed criminal issues, but very foundational issues. Definitions. Two separate cases while I was working at the Supreme Court dealt with how to define immunity in the statutory context of the criminal law. That's a basic affirmative defense. And we had offenses constantly trying to figure out, what is an element, what is an exception to that offense. These are things that should be outlined in the criminal law. So when my boss unexpectedly announced his resignation in January, I caught wind of this project at John Locke, and in speaking with John Guzet, I learned more about the project. One great resource that I was introduced to was a paper by Professor Jessica Smith at the UNC School of Government called Criminal Code Recodification for North Carolina. And so I'll put that up on a slide later, but if you're interested in this issue, it's a fantastic resource for everyone to become acquainted with some of the problems with the criminal code. So the criminal code in North Carolina is a mess, plain and simple. There was an empirical study done in 2000 by Professor Paul Robinson, who at the time was in Northwestern, now he's at the University of Pennsylvania, and he is an expert in this particular topic. And he found that in ranking all of North Carolina's, or all of the criminal codes in the United States, all 50 states, the District of Columbia, and the federal criminal code, that North Carolina's ranks 43rd out of 52 in terms of clarity, in terms of comprehensiveness, and its cohesiveness, and its accessibility. So one of the interesting quotes I found from that study was in one of the questions that they asked of each of the codes, he described North Carolina and a few others as having hardly a code at all, but rather a patchwork full of holes. And I think that's an apt description. I mean, since that study was done, North Carolina's code has further blossomed, and it's outpaced all of our neighbors. We've had more crimes come up in the last 10 years than all of our neighboring states, and I've put where our neighbors ranked on that study, just for reference. So why does North Carolina's code rank 43rd? Why were we so low? And I think you have to go directly to the source. Our code is literally all over the place. You start with Chapter 14 of the General Statutes. Chapter 14 is entitled Criminal Law. And if I'm the average citizen, I think that's a reasonable place to say, well, if it's in here, then it's a crime. And if it's not in here, it's probably not a crime. But if you're a lawyer, or if you've happened to glance through some of the criminal code at some point, you know that's not the case at all. And in fact, there are crimes defined in more than 140 chapters of the general statutes. Thousands of crimes. And in reading these crimes very closely, you find that some of them say, any violation of a rule or regulation promulgated under this article is a Class 3 misdemeanor, or a Class 2 misdemeanor. So you also have to go to the administrative code and the thousands of pages in the administrative code to find out what's criminal. And if you're a particularly careful reader, you'll also notice in Chapter 14, Section 4A makes any city, county, town, or municipal sewerage district ordinance a crime. It's a Class 3 misdemeanor to violate any of these ordinances unless they fall into a narrow exception. Now, fortunately, you don't have to read all of these pages to know that there is a problem with the code. This in and of itself is a problem. But as you start to read through these rules, you also start to see patterns emerge. patterns that are troubling. There are undefined crimes in our criminal code, things that are still defined by the common law. And if you're not familiar with what common law is essentially judge-made law or customary law. It's what we inherited from Great Britain. We have incomplete crimes in the criminal code, crimes that may define some elements but don't have everything defined. One particular issue arises with mens rea. So mens rea is just your mental culpability. The foundation of any crime is going to be two parts. You're going to have the actus reus, or the guilty act, and the mens rea, or the guilty mind. And so what we believe that an act that is criminal doesn't become criminal unless there's criminal culpability to it. You intended to do that. You intended to bring about that result, or you were reckless in bringing about that result. This is foundational to any system of criminal law. But in North Carolina, a recent study from the Administrative Office of the Courts found that roughly 2 out of 3 felonies, not misdemeanors, felonies, are missing a criminal, or are missing a mens rea element for at least one element of the crime. And that's a real problem, because then you wind up having accidental criminals. People do something without knowing that it's criminal, and they are strictly liable for that if the court interprets it accordingly. You have crimes that are redundant. You have ordinances that overlap statutes. You have statutes that overlap statutes. And one particular problem that we're going to talk about today are statutes that look like they overlap other statutes, but really don't. That may seem odd, but because our system is predicated on the criminal law, the common law, a lot of our crimes are not overlapping, but they're really just patches. You have unconstitutional crimes, crimes that violate the First Amendment, crimes that violate the penumbras of the Bill of Rights. And you have crimes that are obsolete. Perhaps these were problems 100, 150 years ago when they were defined by statute, but they really shouldn't be on the books anymore. And even if they're not acts that aren't committed today, maybe we don't think that they deserve that community condemnation that comes with a criminal record. So it's worth asking then how we got here and how North Carolina's crime got to this state. And as I've been alluding to, and as the title of today's talk alludes to, it's because we're working on an outdated system of criminal law. So North Carolina's crimes come from the common law. And in fact, there is a statute, ironically enough, that puts the common law in force. There was, I believe the first statute was passed by the colonial legislature in 1715 that made the common law, or put the common law in force here. And there's possible reasons for that I won't go into. That's beyond the realm of my knowledge. But in 1778, not long after we declared independence, we reiterated that to make sure that the colonies didn't slip into anarchic disarray, right? So all such parts of the common law as we're heretofore in force are hereby declared to be in full force within this state, subject to some exceptions. And that includes all the crimes. And this was common. This was the way that our criminal model operated in all states in the 18th century. Now, in the 19th century, there was a codification movement. People sought to write down crimes, or sought to write down all areas of the law, to write down the common law and make it more accessible for people so that everybody understood what the law was. And for some reason, the codification movement largely missed North Carolina, or at least in terms of the criminal law, it missed North Carolina. Because many of our crimes didn't go defined in the general statutes until the 20th century, and some late into the 20th century. And I'm not talking about petty small crime. Serious felonies like kidnapping were not really defined well by statute until late in the 20th century. And in fact, some of our crimes remain undefined. Common law robbery is still a charge in North Carolina. It is still a crime in North Carolina that has never been defined in the general statutes. Larceny is another example that's been a favorite whipping boy. It's come up over and over and over because larceny is not defined in the criminal statutes. Now, I was in the Marine Corps, and when I was in the Marine Corps, there was a common saying about the Marine Corps' tradition, and I think it holds true for North Carolina's criminal law, because I think the criminal law represents a couple centuries of tradition completely unhampered by progress. And I don't know how many of you have worked in government. I've worked in both the legislature, the judicial branch, and been in the military, and I've always heard the phrase, that's the way we've always done it, and it's always bothered me. So if that bothers you just as much as it bothers me, then the rest of this talk should be of interest to you. I want to use larceny as an example of how this has come up. So as I mentioned, larceny is not codified in the common law, or not codified in our statutes. Rather, it retains its common law definition. And this definition is what was written down by Blackstone in the 1760s. So for those of you who are unfamiliar with William Blackstone is one of the great celebrated common law writers of 18th century England. And his treatise, his commentaries, came in 4 volumes, and they were the authoritative source on what the common law was in the 18th century. So in the latter half of the 1760s, he writes down this definition: the felonious taking and carrying away of the personal goods of another. This definition is essentially what larceny is in North Carolina today. Now, North Carolina's courts have teased some of this out a little bit more. Felonious, the second word, has been, there's some meaning to that. It means that the intent to deprive someone of their own property. But there's one word in here that actually has not received any treatment from the courts and hasn't been expanded by the courts. And it's the word personal. Personal goods, personal property. Again, those of you who've been through law school and understand there's a difference between personal property and real property. So real property, things that are attached to the land, were not covered by larceny statutes. Ungathered crops would not be subject to larceny. If someone came on your land and stole your crops, that would not be subject to larceny. Animals, generally, are not subject to larceny, although there were some minor exceptions for that. Any real estate professionals in the room will tell you that fixtures convey with the land. They become part of the realty. So if for some reason someone came into your house and stole a curtain rod or an oven, that wouldn't be subject to larceny laws. Now, instead of redefining larceny, the General Assembly has passed a number of statutes throughout the years that include new things into larceny. So I mentioned ungathered crops. They made it, in 1811, the General Assembly made the theft of ungathered crops larceny. They made horses, mules, swine, cattle, and dogs larceny in 1866, and I think about 100 years later they expanded that to be all animals. Home fixtures all animals. Home fixtures was added in 2008, which is really strange to me. I don't know. I'm sure somebody in the room knows why it took that long for that to happen. But I'd really be curious as to what the impetus was. What judge said, well, you stole an oven or you stole a microwave, and that's a home fixture, so it's not larceny. I'd be curious as to how that came up. Pine straw is, I mentioned that larceny had become a whipping boy, and pine straw is the one that's gotten a lot of attention. I actually do know the story of how this came about. So in the 1990s, we have landowners that have these coniferous trees, pine trees on their land, and they'll go around and they'll rake up the pine straw and they'll sell it to landscapers or whomever, and they can turn a profit on that. Apparently, it's a pretty decent business. But in the 1990s, they had a real problem with people coming around and raking up their pine straw. And they'd go out to try and harvest the pine straw, and it wouldn't be there. And so they approached law enforcement, and they got a kind of a baffling response. Well, pine straw is not a crop, so it's not larceny. That's still real estate. And so it doesn't fit into that common law definition of larceny. So these landowners decided to petition the General Assembly, and in the 1990s, I think it was 97, the General Assembly passed larceny of pine straw and pine needles. So that's an interesting one. There are a few other things that they've added throughout the years. Let's take a look at those. Milk crates, motor fuel, goods from construction sites, secret technical processes, public records, wills, portable toilets, political signs. you see there are either a lot of loopholes to common law larceny or a lot of really good, strong special interests, and maybe a combination of the two. But this translates into an impenetrable kudzu for the average person who wants to know what larceny is in North Carolina. And so I think, and I would hope you would all agree, this is a real problem. And this is just one example. They could have, but at this point, they haven't defined it at all. And again, it's not limited solely to larceny. It's breaking or entering, burglary, robbery. These things have never been defined in our code. So we actually have never, we're talking today about recodification, but we've never actually codified the criminal law in the first instance. So it's not so much a recodification effort as a codification effort. So there are, as you can imagine, a number of issues that arise from this. The first that I want to talk about are false positives and false negatives. So what I mean by false positives are people who are being punished for things that we don't really believe deserve community condemnation. And we saw an example of that, I think, in February in Greensboro, if everybody remembers the Joymongers incident. I don't know if you're familiar. So Joymongers is a very popular tap room in Greensboro that allowed dogs to come in because they didn't serve any food. They may serve popcorn, I don't know. But they served primarily beer. And people would bring their dogs after a long day at work. They'd sit down. They'd have a beer. They'd talk to each other. Their dogs would socialize. It was a really popular place in downtown Greensboro. But one day, as the government tends to do, it decided to get involved. And it went to, the Greensboro Health Department drafted a letter, sent it to Joymonger saying, you've committed a Class 3 misdemeanor. You're in violation of the health code. Now, never mind that Joymongers didn't have this problem at their primary location in Winston-Salem. This arose out of an ambiguity in the law, where we took an ambiguous regulation, and the Greensboro Health Department said, you're in violation of the law, cease and desist. Now, the reason I call this a false positive is primarily because the local populace who enjoyed going to this bar was furious. And if they're furious about this potential for punishment, then I think we can safely say that the criminal law did not reflect what the community felt should be condemned. And so here you had regulations that hadn't been passed by a democratic process, but rather by a regulatory agency that was criminalizing behavior that the local population felt was ridiculous. And there are certainly all kinds of examples of false negatives that arise. One that I was talking about earlier and that I've written about is a case that I worked on at the Supreme Court, State v. Rankin. And in State v. Rankin, I'll just tell you this story very quickly. You had a woman who was convicted of felony littering. She had gone out, found a tank on the side of the road. It had fuel oil in it, heating oil in it, dumped it in a yard, dumped it in the street. It got into the water system. I don't know why all my stories come from Greensboro, but the Greensboro Health Department, once again, had to spend more than $10,000 to clean this up. And so she challenged it on the basis of an ambiguity in the law at the trial court. And then she challenged it in the appellate courts for a different reason. She challenged it saying, well, her indictment didn't include all the elements. So because the law was unclear, we spent 4.5 years on this case. That's 4.5 years of lawyers' time, 4.5 years of investigators' time, 4.5 years of judges' time. And there was no conviction at the end of that. Despite the fact that she had admitted to everything, there was no conviction because of ambiguities in the littering statute. Another issue that has arisen, unequal application of the law. Criminal rules should be as clear as possible to limit unequal application of the law. We're talking about something that is core to the American experience. This isn't a partisan issue. This isn't left-wing or right-wing. This is about making sure that if you are going to deprive someone of life, liberty, or property, that the rules that allow you to do so are clear. That's due process of law, in my opinion. I realize the court hasn't interpreted it that way exactly. But that, to me, is a core, fundamental principle of the American ideal. And as I discussed with the State v. Rankin example, we also have a lot of wasted judicial and taxpayer resources as we pay a lot of money to send these issues through the courts and allow the courts to define what the criminal law is. And I'm not saying the courts do a particularly poor job. I'm saying that that's a very inefficient system to spend 4.5 years on litigation just to find out that, well, when we indict someone for littering, we have to also say that it wasn't done at a dump without permission. So the answer to this system, we have very straightforward fixes that can address some of these issues. We can repeal unconstitutional laws, and most people wouldn't bat an eye about that. We can revoke the authority of agencies and municipalities to create new crimes. That would, again, be very straightforward. But what we're talking about here is a bit more involved. I don't know how many people have a background with boats. I spent some time before I went to law school working as a cruise ship musician. And my wife also worked not as a musician, but worked on cruise ships for a while. And one of the things you have to do periodically with a ship is put it in dry dock so you can repair it. You can do some things as simple as fixing the fixtures inside or doing some renovations, or you have to repair the hull of the ship. We've had these little patches that we've tried to patch for so long on the hull of our criminal law. It's time to bring it into dry dock and fully repair it. For the first time, codify our laws. Again, I have recodification written up here. Maybe that's a bit of a misnomer. So what would a recodified criminal code look like? The first thing it would have is a robust definitions section. We have a robust definitions section. I mean, oftentimes you can tweak these definitions so that it applies to new conduct that's arisen. Because obviously we don't have the gift of foresight. We don't know what kinds of behavior is going to be outrageous 10, 15 years in the future. I mean, 20 years ago, I'm sure nobody thought we'd be talking about regulating speech on Facebook. So we need to have flexibility in order to adjust to new situations that come up. A robust definition section would give the General Assembly flexibility to respond to these issues in the future, while also ensuring, to the extent possible, that the application of the law is similar from case to case. It's equal, because that is a goal we're striving toward, right? Clear general principles of liability. Most of our affirmative defenses have no definition in the criminal law as it currently exists. They're all defined by the common law. So things like justification, when a person is justified in doing something that we would normally consider criminal, or excuse, like insanity, when they are excused from behavior that is criminal. Immunity, as I mentioned earlier, came up twice while I was in my 6 months at the Supreme Court. And these are basic issues that ought to have full treatment in a criminal code. Similar with mens rea. We talked about how many of our statutes fail to define mens rea for at least one element. We ought to have clearly defined mens rea terms. Right now we use terms like wanton or willful or feloniously. And the model penal code uses a more simple system. I mean, I'm not advocating necessarily that we adopt it, but the model penal code has purpose or intent, knowledge, recklessness, and negligence. And on top of that, the model penal code also adopts a default mens rea standard, where they say if the General Assembly or the legislature fails to define what the mens rea is for that element, it defaults to recklessness. Now that's, the benefit of that is having some intentionality behind the code. If we're going to create crimes that have strict liability, whereby you do the crime and it doesn't matter what you were thinking when you did it or why you did it, you're guilty of it, that should have intentionality behind it. If we're going to hold people strictly liable for that kind of behavior, there should be some intentionality. There ought to be an express legislative intent to hold people liable at that level. So clear general principles of liability would help us accomplish a lot of those particular aims. A new criminal code would also have a comprehensive, accessible definition for every crime that can be charged in North Carolina. No more common law crimes is, I think, the biggest takeaway here. We allow the common law to dictate when people can be charged and when they can't be. There's a problem in that most people don't have access to, or if they have access to the opinions that define this behavior. A, you've got to comb through a lot of language to get to the definitions of these crimes. And B, a lot of times you have to have legal training in order to do that. Now, there are going to have to be adjudicative principles outlined in a new code that are probably best left to the lawyers and the judges. But in terms of what is criminal and what is not, that should be clearly outlined. To think of it in terms of an analogy, the criminal law shouldn't operate like a bear trap in the woods where you step in and it catches your ankle and the government says, gotcha. Instead, it should be a very clearly defined area where we tell people this is a line you cannot cross, and everyone knows not to cross it. And if someone does in fact cross into that area, then they're held liable. Because again, we're talking about a deprivation of life, liberty, or property. So I said earlier, I mentioned the paper by Professor Smith. I want to go ahead and put that up for anyone who's interested. Criminal Code Recodification for North Carolina. Professor Smith has been instrumental in getting this ball rolling and having this discussion with a lot of people throughout the state. And her continued leadership is going to be necessary to this project. But if you're interested in getting more of a foundation on where this project ought to go, where it needs to go, what the problems with the criminal code are, this is a fantastic resource, a fantastic primer. So, as I said, I came to the John Locke Foundation specifically to take on this project. It's something that I'm very excited about. Was very frustrated with the problems that arose with the Supreme Court, and so when this opportunity popped up, I jumped all over it. And we are excited about seeing how far we can take this and pushing it over the goal line to get North Carolina clear rules of criminal liability. So with that, I'll take any questions that anyone has, although I'll ask you again. She mentioned I've only been here for 2 months. I've got a 90-day review coming up here in a month, so softballs only, please.
Okay, that's a first, I think. Okay, questions or comments?
I wonder who number one was, which state was number one, and whether there might be some copies possible.
Could you take a guess as to which state was number one? Oh, that would really stick in my craw. Couldn't be California. No, it was Texas. And so one interesting thing that Texas had, they've had ongoing codification efforts. They've had commissions that have come together for the purpose of rewriting their code recently. And this is an ongoing effort for the state of Texas, is to rewrite their criminal laws. So that's one model that we could look to, although they're not the only one. I think just for everyone who said California, I think California was in the lower 30s, so still ahead of us, but a little closer. Yes, sir.
Prosecution going forward, because they may not want to touch this briar patch. In other words, you mentioned like you got 140 different chapters where you can find all of this stuff.
Right.
So we probably can't go forward with a valid legal system because you don't want to go there.
Well, that's an interesting point. I actually think. And if anybody here works in law enforcement, I don't mean to impugn anybody's motives here, but generally, when the code gets into this kind of state, it tends to work more in favor of the prosecutors, particularly with the redundancy. So if you have a criminal code, you have somebody who's committed a crime, it's more effective for you to get a guilty plea if you can show them a litany of charges. Right? And you say, these 10 things we're charging you with, and never mind the fact that you'll probably get consecutive or suspended sentences for a lot of this, you're facing a lot of time. If they have to come and they say, here's 1 or 2 things you did, it's a less effective tool. But I think that there's still advantages to the prosecutors for having a clearer code. So if the code is clear, then we have a brighter line about what is criminal behavior and what is not. And if that line is brighter, then somebody's going to be more clearly inside that box or outside that box. And if they're more clearly inside that box, they have much more incentive to take a plea deal rather than to try and risk it with a jury, right? So what we want to do is we want to try and cut down on unnecessary litigation. We can never get rid of that ambiguity. We're using language, and language is inevitably ambiguous at times. But we can be as clear as possible to draw as many bright lines as possible to avoid things like prosecutorial abuse, just simply for the sake of getting a guilty plea. Yes?
So I am from law enforcement, but I won't take it against you.
Again, I'm not trying to impugn anyone's motives.
But Texas, they've seen a steep decline in their recidivism rate. Would you also give that towards their updating of the penal code?
That's an interesting question, and I don't know that. I don't know how this would affect recidivism. I know that there are a lot of other reform efforts that can cut down on recidivism. But one thing about recodification that might help with recidivism is that if you recodify the criminal code and you make the laws clearer, then all of these other efforts, like bail reform, for instance, become much more effective because you're operating within a clear set of parameters rather than operating with this. The criminal law right now has got its tendrils everywhere, right? It's sunk into everything. If we cut that out and we say, listen, this is the box, don't cross into the box, then we can move forward with things like bail reform and sentencing reform in a more effective manner that could cut down on things like recidivism. Yes, sir?
Thank you for my question is, if there is consensus about recodification, what would you say is sort of the best process? Is it start with the model penal code and work from there? Is it start with a list of all the laws that currently exist and decide which ones you want to carry forward? What would you suggest?
Right. So that's a great question, and I think the first place, if nobody, I don't know if everybody on this side of the room heard it, but the question is, if we decide to move forward with criminal code recodification, where do we start? Do we start with the model penal code and move from there? I would say nobody, to my knowledge, has adopted the model penal code in full. And what they've done is they've adopted the principles of the model penal code, but within the policy choices, I think, of their own state, generally. I think that has to be where we start in North Carolina, is we have to look at the policy decisions of the General Assembly and retain as many of those as possible as we move forward, just expanding definitions to encompass something. Again, we go back to the slide with all of the different larceny charges, a description of larceny that encompasses all of these things that we want to have fit into larceny, rather than simply just applying a patch. So if we start with North Carolina's criminal code, and again, this is going to require experts. That's why I keep throwing the name Jessica Smith out there, because Jessica Smith knows the criminal law, I think, better than anyone else in the state. But if we have people who know the criminal law in North Carolina, know the policy judgments that we want to preserve, that's probably the best place to start, while then drawing in the principles of the model penal code and trying to have fully or clearly defined principles of liability and have clearly defined terms that are going to be used throughout. That's my idea on it, but we'll see if we get the commission, which we're certainly hoping to do, to get a recodification commission. We'll see where that goes, but that's certainly a conversation that's going to happen. That's a great question. Yes, sir.
The arguments you presented about providing the citizenry with notification through a codification of what is a criminal offense and what is not makes sense to me, and how that would be better than relying on the common law.
Right.
And additionally, through legislation, at least it's more of a democratic decision than if it's just judge-made law. But do you know what the rationale is for maintaining a common law regime in the criminal field or other fields such as tort law or contract law rather than a codification regime? What are the pros of that?
So, okay, that's a great question. The pros of the common law system in criminal law or any other area of law. I think one of the pros is the ability to, the United States Supreme Court uses the term percolation, and we allow the lower courts to percolate on an issue. So they'll sit there and they'll consider it, and they'll see all the different solutions that lower courts and the circuit courts of appeals have come up with. And if there's a split between the circuits, then the United States Supreme Court will take up the issue, and they'll have all of this information in front of them about what the law should be in this area. So I think percolation is something that that the common law allows us to take advantage of and to see how the courts of appeals handle. But the problem is that we don't have different circuits in North Carolina. It's all coming up to the same court, and ultimately when that court decides, that's the end of the matter. I'll give you an example with robbery right now. There was a case before the Court of Appeals, State v. Cox, in which the issue was that somebody had given someone $20 to go buy drugs for him, and she didn't go buy the drugs, so he and a few friends broke into her house with a gun and beat her mercilessly until they finally relented, saying, well, she doesn't have our money, let's go. Now, he was convicted of attempted common law robbery, among other things, and burglary, which, again, for the non-lawyers, burglary is breaking into, I'm oversimplifying this, but breaking into someone's home with the intent to commit a felony at night. So if it's during the day, I think it's just breaking or entering. But he was acquitted of attempted burglary and burglary and attempted robbery. And the reason he was acquitted at the Court of Appeals was because they were considering the question of whether or not you could commit robbery in getting back your own stuff. He had loaned her this, or he'd given her this $20 to go buy drugs for him, so he had what they call a bona fide claim of entitlement or bona fide claim of right to this money. And they broke into this house, they beat this woman mercilessly, and that wasn't robbery. And because it wasn't robbery, there was no underlying felony to attach to the burglary claim. So the only thing that Mr. Cox was ultimately convicted of, not even assault, it was just for firing a weapon into the house and into an occupied residence because he'd done that as he left. So these are and the reason I bring this up is because in terms of percolation, the court's gone back and forth on this issue. Whether or not a bona fide claim of right to that property allows you to do something like this. And so over the last 50 or 60 years, the court's gone back and forth, and it hasn't been clear. So the problem is when we start to percolate with one court of appeal, one appellate court, intermediate appellate court, and one high court, that ultimately what you wind up getting is just flip-flopping back and forth on the issue. And ultimately, someone needs to be the arbiter and come in and say, this is the law. And that body should be, if we're talking about crimes and community condemnation, the branch that, in theory, is supposed to be the closest to the communities, the legislature. But that's a great question. Yes, sir?
I know it's early in your project, but have you had a chance yet to identify prospective legislative champions for what you'd like to do?
Absolutely. So right now we've been working a lot with a couple of different legislators on this issue. One of them's in the room right now. Representative Rydell has been instrumental in helping us keep this ball rolling, along with his colleague Senator Wells. And we've also recently had the opportunity to sit down and speak with Senator Daniel. I know Andy is over here in the room. Appreciate you coming out. But yes, we're working to try and get the ball rolling on a recodification commission. We're just trying to find the right vehicle for that, or we're trying to convince them of what the right vehicle should be as we discuss these issues with them. Yes.
Along those lines, can you just talk, I mean, you described a really big problem,
Mm-hmm.
a long-standing problem. This is going to be a big lift to fix it. And you talked about the commission, those kind of things. Can you back up just a little bit from there and just talk a little bit about some of the things that Representative Rydell, Senator Wells have done to begin this process? I mean, I think that's a interesting piece of the story. And where do you start to unravel this?
Absolutely. So I've mentioned, I guess, a couple of things throughout the course of the presentation without mentioning where they come from. We talked about an AOC report where 750-ish of the felonies outlined in the AOC report, AOC, Administrative Office of the Courts. 500 of those failed to define a mens rea for at least one of those elements, right? That came about as a result of working group legislation that was passed by the General Assembly in 2018. So in 2018, they passed a bill requiring the Administrative Office of the Courts to report on every statutory and common law crime in existence, and to give certain facts and details about those crimes, whether or not there's a mens rea defined for each element, for example, whether it's obsolete or rarely charged, and whether there are undefined terms in these statutes. And so AOC provided that report. They also required every town, city, county, I don't know if municipal sewerage district was in there, I believe it was, to provide every crime that could be committed by someone within their jurisdiction. And a lot of them came back with a report that had at least a handful of their ordinances in it. Some came back with a troubling answer that there was nothing that they had passed that was a crime, which is a problem because by default, if it's not parking or driving related, that ordinance is a crime. And so it seems to me, extrapolating here, but you put 2 and 2 together and you see that they're passing new crimes, creating new crimes by accident, which goes back to the intentionality I was talking about earlier. So that's one vehicle or one step that the General Assembly has taken to get us to where we are right now in our understanding of the problem. Another step that they've taken, there's a bill recently filed on providing a few stopgap measures, one of which is revoking municipal authority to create new crimes, specifically for the reason they're being created by accident in some places. A review process for the General Assembly on regulatory crimes. There's a default mens rea provision that's in a proposal right now. And there are a few other things that have been proposed in terms of correcting these issues. A stopgap provision, or a sunset provision rather, on municipal crimes and on regulatory crimes. So there's a lot being done right now by the General Assembly in order to set this up. And as we're moving towards a commission, as we're moving toward getting a wholesale revision of the criminal law, we are taking, or the General Assembly has taken many positive steps to get us there. Yes, sir?
So we love change in the government.
Right.
This is a huge elephant, right?
Mm-hmm.
That we were just talking about. What kind of roadblocks do you see out there that are going to stop this from progressing forward?
That's a great question. So the first is agreeing on what the vehicle is. There are a lot of people who may not want to see a new commission because there's, I don't know, half a zillion right now that they have to have somebody full-time vetting appointments in the Senate. So there's problems that we have with just the vehicle, and there's some disagreement over what the vehicle should be to get this done. Agreeing on the first steps is going to be a roadblock. Once the ball gets rolling, I can't speak to what the climate is in North Carolina. I've spoken with Professor Robinson, the author of the study I mentioned at the outset, and he said that he's chaired three recodification commissions that's a mouthful, 3 recodification commissions in different states, and he said that each time the roadblock has been the prosecutorial community. So just getting the DAs to back this. I don't know what that'll be like in North Carolina, and obviously even the earliest discussions of this commission should probably involve them to make sure that they are on board. And to my knowledge, they have been included in these discussions and in the working group 2 years ago. So we're hoping to mitigate a lot of these roadblocks. And I think that the last roadblock is simply the amount of time that it's going to have to take. If this is a project that takes 2 years to get done, one of the obstacles to that is it just falling out of the public's consciousness. And when the report finally comes back to the General Assembly, it's off everyone's radar. And that's why I've been hired, is to make sure that people are, I guess, constantly. It's in front of people constantly. It's in front on our website at John Locke. It's on Carolina Journal, and hopefully in other publications, so that people can constantly be reading about this. Mitch.
Go back to the study and the ranking.
Yes, sir. Okay.
South Carolina was in the worst shape that we were at that point. The other neighbors were a little better, but they were sort of middling below 25th, except I think Tennessee.
Tennessee.
Is there anything about where Tennessee stands, code is that can help in this process? Say, look, our neighbors just west do better than we do. Is there something there?
I don't know. There's a whole mountain range in between us that makes it kind of difficult. No, I mean, I'm certain there is. I'm certain that there are principles that we can look to there, but I mean, ultimately we know what a good criminal code should look like. There are a lot of examples out there. I find it interesting that Tennessee is so highly ranked. One of the other states that was right around Tennessee was Kentucky. And after Kentucky, this was, again, was in 2000, after Kentucky had been placed so highly, they then sought to recodify their laws. Professor Robinson had been brought on to chair this commission to recodify their laws. I think it was 3 or 4 years after that study was done. And I don't think that was successful, but I find it interesting that they're in that region, kind of the landlocked Appalachians. They've obviously put great focus into their criminal code. And so I'm sure that if we were to take a closer look, we would start to see these principles emerge, the same principles that make Texas a clear code. I would imagine that their codes here are self-contained, that they prohibit the use of common law crimes in charging a defendant, that everything has to be written down in order to charge someone. These are important principles that, again, I mentioned that Professor Robinson defined our code as hardly a code at all, more akin to a patchwork full of holes. And the principal reason for that is that, A, it's all over the place. We have all of these thousands and thousands of pages outside of the criminal code that define criminal behavior. But the other reason for that is that we allow common law crimes. So on top of these thousands and thousands and thousands of pages of rules and regulations and laws and ordinances, you've got another thousands and thousands and thousands of pages of court decisions. And having spent a number of years now reading these court decisions, I can tell you nobody wants to comb through that. That's a headache. Anyone else?
We'll take Tony real quick, and then we'll
Could you draw a parallel between the performance of the court system in North Carolina with Tennessee to show the value add of adopting a better system? There must be a greater cost on our end.
Yeah, that's a great question, and I have no idea. So that's all I can say. There goes my 90-day review.
There may not be an answer to this question, but how does this happen? I mean, you have one big piece of legislation that goes through and does the whole thing, or do you do it, incrementally through the legislature over maybe years?
A great question. So the question for those who are unable to hear it is, do you do this incrementally, or do you, with patchwork legislation throughout the years, or do you try to do this just in one large bite? I think the answer has to be one large bite. And I know that might seem a little bit daunting, but it wouldn't be the first time we've done this. Interestingly, in the late 60s and early 70s, our Attorney General at the time recognized that there were some issues with the criminal procedure laws in North Carolina. So we're talking about just the adjudicative rules, not necessarily the substantive crimes. And so he pulled together a commission of people that spent some time rewriting the rules of criminal procedure. And I think it was in 1973 or 74, they had this proposal. They gave it to the General Assembly. It's a book about this thick, and you can flip through it, and you can see every single statute that they proposed, every single change, a commentary as to why those changes were proposed. And the General Assembly passed, I think, the whole thing into law in I think, one or a handful of bills. So it is something that can be accomplished, and it's something we've done in the past in North Carolina. It's simply a matter of getting the ball rolling or keeping the ball rolling on this issue.